So up till now, we've learned that the early cases, which had said that courts should not get involved in elections or in protecting voting rights, were then replaced by some sort of foundational precedent in the 1960s with Harper versus Virginia Board of Elections and similar cases that said that no, that courts can interpret the Equal Protection Clause as protecting voting rights. And we discussed that, while the court says that strict scrutiny applies to restrictions on voting, it can't possibly be the case that all restrictions on voting should be struck down, whether it's categorical exceptions to the normal rule of the equal right to vote, say when it comes to felon disfranchisement or mental competence or residency or citizenship or age. There are exceptions to that general rule. But then just in the kind of garden variety administration of elections, there are going to be all kinds of burdens that are placed on individuals when they try to vote. And that can be true in the registration process, the voter identification and verification process, the location of polling places, wait times, the manner of voting, whether you're talking about, say, voting by mail, voting early, or how long the period for voting is. All of those different kinds of restrictions, which make up election law, are going to have some burdens on some voters, such that maybe some of them wouldn't even end up voting. And so how do we navigate these sort of two classes of cases? When do we think election law is presumptively unconstitutional versus presumptively constitutional? As a general rule, those kinds of categorical discriminations must survive strict scrutiny. You see that from Harper. With those exceptions that are textually based. And then you've got these other kinds of restrictions on voting, sort of election regulations, which the court is subject to a kind of balancing test, such that if they cause a severe burden on the right to vote, maybe they'll be struck down, but otherwise they're likely to be upheld. One of the difficulties here is that all election regulation makes it difficult for some parts of the population to vote. So think about whether you live near a polling place or you live far away from it. If you live several miles away from a polling place, is that a constitutional problem? Similarly, if you move a lot of the time and you have to re-register to vote in order to exercise the franchise, is that an unconstitutional restriction on your voting rights? So there's all kinds of aspects of the electoral process that create burdens, and it can't be that all of them are unconstitutional. Many of them are absolutely critical parts of the process, whether it's ensuring the integrity of the election, preventing fraud, or just trying to run an election where you have hundreds of millions of people who are attempting to vote. And so the court has said that, look, when it comes to these kinds of election regulations in Storer versus Brown, it says there's no litmus paper test that can separate constitutional from unconstitutional regulations of the voting process. Some kind of balancing is necessary and inevitable. And so while there are many different cases related to this kind of regulation, and we'll talk about some of them in subsequent lectures dealing with ballot access, I want to spend most of this lecture talking about voter ID laws and voter identification in general. So this is, of course, a quite polarizing and hot topic these days, but I thought it might be useful to give a little bit of the history of voter identification laws and the voter identification controversy in the US. I should say that, when you talk to folks from other countries and describe how controversial the issue of voter identification is here in the United States, they're usually confused and surprised, in part because in most countries, there's a national ID card or some kind of, passport that everybody has. But we don't have that in the United States. We don't have a national identification system or a national citizenship list. And most people are sort of surprised to hear that. And as a result, what that means is that most types of, at least state-provided identification that voters have is usually either a state ID card or most likely a driver's license. And so all of the socioeconomic biases that play into whether someone is likely to drive or not are then going to play into whether they have identification that's at least state provided. And so That's sort of the core of the controversy, is that voter ID in the U.S. is sort of different than voter ID many other places, because depending on who you ask, roughly 10% of Americans don't have a state-issued form of photo identification. And each one of those phrases is important: state-issued brand of photo identification. Um, and so this has become a polarizing issue among the parties, although a majority of Americans are in support of voter ID. Um, and the voter ID movement, really, the modern voter ID movement, begins after the 2000 election, in the run-up to the Help America Vote Act that was passed 3 years later. So um, the 2000 election, the Bush versus Gore, very close presidential election, then led to reforms of the voting process. And through a bipartisan deal with the Help America Vote Act, you ended up with provisions the Democrats wanted, provisions that the Republicans wanted. And one of those was the first voter ID requirement provided in federal law. And what it said was that for first-time voters who registered by mail, they needed to show some form of ID. But this was not like a state-issued photo identification. It could be a utility bill or any number of other kinds of identification, like mail, certain types of mail that you might receive at your house. But that was just for first-time voters who registered by mail, could be required to show some form of ID. And what we saw in the wake of the 2000 election, HAVA 2004 election, right around that period, was that many states started the process of requiring voter identification. It wasn't first required there. There were many states that required voter ID before that. But the kind of modern controversy of voter ID starts in that first 6 years or so after the 2000 election. And one of the sort of central problems when it comes to litigation over voter identification is that it's sort of difficult to find individual plaintiffs who are absolutely prohibited from being able to get ID in order to vote. It's just that it's sometimes very burdensome. A lot of people don't have birth certificates. A lot of people don't have the requisite documents that are necessary in order to get a driver's license or state ID. But it's also very hard for the defendants, for the states, to prove that voter ID is necessary to prevent fraud, because that's usually the rationale for a voter ID law, is that it's needed in order to prevent in-person voter impersonation, right? So that voters are going from one polling place to the next, impersonating, either dead voters or trying to vote twice, and that voter ID would prevent that, and that's never been shown to be a very big problem. And so you have this problem of it's difficult often to find plaintiffs who are going to be absolutely prohibited from voting because of an ID law, but it's also hard to show that vote fraud, the kind that would be prevented by a voter ID law, that is as pervasive as many as the states would like you to believe. And so what we've seen up through the 2022 election is a sort of familiar pattern of states, largely in the South and middle of the country, that have voter ID laws. But just because you call something a voter ID law doesn't mean it's a very difficult voter ID law to comply with. Many of these states will have laws that you require that you present a photo ID, but if you don't, that maybe you can sign an affidavit, or you can come back later to prove your identification, or you could have someone vouch for you. All kinds of variations on photo ID. And then some require a state-issued form of photo identification, whereas others require something more along what HAVA requires, where as long as you have some kind of identifying document, you'll be able to vote. And so it's difficult to say that these are the photo ID states, these are the non-photo ID states. There's a long continuum in between those extremes. In the non-photo ID states, how do we verify voter identity? Often it's through signatures on the ballot book or on the envelope on an absentee ballot, so that through a process of matching signatures, you ensure that the person who is actually voting is the person who is registered under that name. And then in some states, you'd have an opportunity to cure any problems with the signature, just as you might have a process to cure any disputes over photo identification. I'll just say, as a matter of statutory law, under the Help America Vote Act, no one can be turned away from the polls for failure to provide photo ID. They simply would have to vote a provisional ballot and then to have that identity verified later. But there is a continuum of photo ID requirements or ID requirements throughout the states. And the court in this case called Crawford versus Marion County in 2008 took it upon itself to now adjudicate the requirement of a state-issued photo ID for voting at a polling place. And the court upholds the photo ID law at issue there against a challenge that was brought by those voters who did not have photo ID. In the Indiana law, the photo ID was free, although it might require that you have to get supporting documents like birth certificates, where that might require a fee. So in these voter ID laws, there's often a question as to, how similar are they to poll taxes? Because if you have to pay in order to get the ID or the supporting documents, does that then evoke the concerns of Harper versus Virginia Board of Elections? But the Indiana photo ID law is similar to others in that if you couldn't produce an ID at the polls at the time you vote, you can cure that you can still have your vote counted if you return to a county office later to prove you are who you say you are. But look, for many people, tens of millions of people choose not to vote anyway. And if you're someone who doesn't have a photo ID, would you go through the additional expense and difficulty of trying to get it just in order to vote? And so for many people, the idea that they wouldn't be able to vote unless they were to procure a photo ID is a sufficient barrier so that they won't turn out. But what interest did the Indiana voter ID law serve? Well, the principal reason behind it was the deterrence and detection of fraud, because the argument was that if a person has has a photo ID, that then you can verify they are who they say they are, and then you can prevent them from voting in another person's name, or that you can prevent them from voting in the name of dead people or voting more than once. But also the state sort of recognized photo ID as important to its modernization of its voting system, to try to make sure that the registration lists were accurate, and also to safeguard voter confidence. So the idea that requiring photo ID might convince people that the election was not fraudulent. Now, what do the plaintiffs claim in Crawford versus Marion County? They launch a facial challenge to this law, meaning that they say that the law is unconstitutional in all or most of its applications. They said that over 1 million Indianans didn't have acceptable identification, although the lower court says it's closer to 43,000. And say that, look, this voter ID law, like most voter ID laws, falls disproportionately on specific populations, the elderly, poor, racial minorities, although they're not suggesting that this was passed with racially discriminatory intent. What was difficult for the plaintiffs in Crawford is that they couldn't sort of identify a group of people for whom they would be sort of absolutely prevented from being able to vote. So that made it a little bit different than Harper, where you say, all right, these people are unable to pay $1.50. Really, what went with both voter ID laws, like most of these regulations, it's not that the person will be absolutely prevented from going and voting, but that it's just a burden. It's one that's going to deter them from voting, because it's just not worth it for them to go out and get the documents, to go and wait in line to get, at the DMV, for instance, to get the voter ID. And so therefore they won't end up voting. So the plaintiffs in Crawford suggest that this is just like a poll tax, that Harper versus Virginia Board of Elections should apply, that people without ID are just like people who can't pay a poll tax, and so therefore the law is unconstitutional. Strict scrutiny should apply, that these laws are not necessary to fulfill the compelling state interest in preventing fraud, and so therefore they are unconstitutional. So the Supreme Court rejected the facial challenge to the Indiana voter ID law. Instead of applying Harper versus Virginia Board of Elections and strict scrutiny, it applied a balancing test from cases like Anderson versus Celebrezzi and Burdick versus Takushi. Anderson versus Celebrezzi is a case dealing with ballot access, like the number of signatures you need to gather to become a presidential candidate on a state ballot. And Burdick versus Takushi was a case dealing with write-in votes in Hawaii. So these are similar to this case, to the voter ID case, in that they're about regulations of the political process, although those weren't cases that dealt with sort of absolute prohibitions when it comes to voting, right? They were not about disenfranchisement. They were more about regulations of ballot access and of the ballot itself. And what comes out of those cases is a balancing test, sometimes called Burdick balancing or Anderson balancing, which says that a court evaluating constitutional challenge to an election regulation needs to weigh the asserted injury to the right to vote against the precise interest put forward by the state as justifications for the burden imposed by its rule. And ordinarily, if a law is not seen as imposing a severe burden on the right to vote, it's going to be upheld as constitutional. And while this is not exactly the model of judicial clarity when it comes to a test, it's hard to think of something better, because ultimately a rule like this is going to have to apply to voter registration rules or polling place design and location, even ballot design, whether you have a right to vote absentee or early. And so all of those laws, it's very hard to say, all right, here's the bright line rule, where if you go over this line, it's going to be deemed as being too severe, because all of those rules, all of those regulations are going to hit some voters more than others and make it more difficult for them to vote. So when it comes to the voter ID law, why does the court uphold it? The court says that there's enough evidence of fraud, at least in the US political system throughout history, to justify voter ID as an anti-fraud measure. It even cites to a poem from the Tammany Hall years in New York and other big cities in the US, where the allegation was that people would go from one polling place to the next, voting multiple times, and voter ID would be the type of thing that might prevent that kind of voter impersonation fraud. While the court does give a lot of sort of deference to the state's interest in both preventing fraud and securing voter confidence that the elections are being run in a non-fraudulent way, it doesn't see the plaintiffs as having proven that a significant number of people will not be able to vote because of this voter ID law. So what the court says is that the burden of getting an ID is similar really to the burden of voting, in that it requires you to, go to the Bureau of Motor Vehicles in Indiana to get an ID. And so it's not that severe for most people. And it deems the plaintiffs as not having provided enough evidence about the number of voters who don't have ID and how many of them are going to not be able to vote as a result of this voter ID law. Importantly, what the court says here is not that voter ID laws always are going to be constitutional, but it says that on their face, unless you can show that a large number of people are going to have a severe deprivation of the right to vote, that the court is going to uphold them. However, in certain discrete circumstances, you can launch an as-applied challenge. And by that we mean that if a individual is severely burdened in their right to vote, say that they don't have a birth certificate because they were born at home, or there's real difficulty in trying to get the kind of photo ID law that was required, photo ID that was required in Indiana, they can bring their own court case, they can bring their own lawsuit for themselves as an as-applied challenge. Now, that's usually not going to be the kind of litigation that interest groups are going to engage in, sort of case by case with each individual voter. And look, if an individual has difficulty getting an ID, it's hard to think that they're going to also have the resources in order to bring a federal lawsuit. But I just want to be clear that the Supreme Court in Crawford didn't uphold all photo ID laws. In that case, it was just deemed that the photo ID law did not severely deprive people of the right to vote, or at least not a large number of them, and it leaves open the possibility for as-applied challenges by individuals who face high burdens of the right to vote. And so Crawford is the only voter ID case that the Supreme Court has decided, and how it's going to be extended to these other contexts remains to be seen, although the court is frequently, the Supreme Court and lower courts are frequently confronting these cases of dealing with election administration and these regulations of the political process. How this exception for as applied challenges will play out remains to be seen, as well as what kind of evidence is necessary in order to show that a law imposes a severe deprivation or that it is justified by fraud. But the moral of the story when it comes to Crawford and voter ID laws is that in general, they're going to be upheld as constitutional because they're seen as sort of neutral regulations of the electoral process.